Good morning, everyone, and welcome to today's national webinar, proudly hosted by LookUpStrata. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, and I'll be your host for today's session. We're glad to have high numbers of strata professionals, committee members and owners across Australia joining us for this important webinar. Strata managers and committees are facing increasing expectations when it comes to transparency, ethical practices and contract fairness, especially around agency agreements and strata insurance commissions. This morning's session will unpack how fair contract principles are reshaping strata across Australia, with a spotlight on recent reforms in New South Wales, new ASIC-informed consent requirements, and the broader shift towards more compliant and transparent contracts. These changes aren't just legal, they're structural. They affect how we negotiate, disclose, renew and manage contracts in strata communities nationwide. No matter where you're based across Australia, the issues we cover today will help you anticipate legal shifts and adopt best practice approaches in your schemes. As always, the content is general in nature and doesn't constitute legal or professional advice. If you're dealing with a specific issue, we recommend seeking independent advice. We also remind you that as this is a national session today, there is different terminology used in each state around Australia. So Owners Corporation is also known as the body corporate or even the strata company, and committee is also known as the council. Now, we do take our transparency responsibilities seriously at LookUpStrata. So as I mentioned at the beginning of the session, in addition to owning LookUpStrata, I also own Tower Body Corporate. Now let's meet today's presenters. Carolyn Meighan, Special Counsel at Bugden Allen Group Legal, is based in Perth and brings over 20 years of experience in property and strata law. Carolyn has represented clients at every level of the court system, and her deep understanding of contract fairness, insurance governance and strata disputes will provide practical insights into what's changing and why it matters. Carolyn has joined us for a previous series of sessions discussing the WHS responsibilities facing strata schemes and strata managers across Australia. And also today we have Julia Moroz, Special Counsel at Bugden Allen Group Legal, is based in Victoria and offers a cross-jurisdictional perspective shaped by her work across WA, Victoria, New South Wales, Queensland and Tasmania. Yuli's expertise in insurance compliance, contract risk and regulatory reform means she's ideally placed to help us understand both the national landscape and the real-world impact of these reforms. So very warmly welcome Carolyn and Julia, and thank you so much for joining us for today's session. Thank you.
Thank you. How about I start today? What if I told you that a single clause in your strata contract, one that you've used for years, could now be void? Unfair contract terms have been banned under Australian consumer law for over a decade, but until now, owner corporations haven't been covered. From 1st of July, standard form contracts in New South Wales, like strata management agreements, building services, cleaning and gardening, will be treated as consumer contracts. And that means the same unfair contract terms that apply to individuals and small businesses will also apply to owners' corporations too. Terms that favour one party, limit accountability, or penalise only one side are no longer just risky, but they are unenforceable and in some cases attract serious penalty. Today, we're going to unpack the challenges, share some examples of what won't pass the test anymore in New South Wales and the impact on other jurisdictions as well. So before we go into that, I just wanted to take a moment to discuss the why behind these reforms. The Strata Scheme Legislation Amendment Bill 2024, introduced in November last year, is part of a much broader reform agenda from the New South Wales government, aimed at making strata fairer, more transparent and more accountable. Specifically, the bill responds to recommendations from the 2021 review of the Strata Scheme Management Act. One of those recommendations, number 57, called for stronger protection against unfair contract terms and agreements offered to owners' corporations. The issue was that under Australian consumer law, protections against unfair terms have only applied to consumers since 2010 and to small businesses since 2016. But owners' corporations were not covered. They fell outside the legal definition used in the ACL, despite being responsible for a significant amount of contract and service arrangements. This obviously created a clear gap in protection. Owners' corporations would often find themselves bound to standard contract terms with little room to negotiate, and with terms that would be considered unfair in any other consumer or small business context, ultimately detrimental to the lot owners and others in strata living. So these reforms fix that. So since July 1st, Owner corporations in New South Wales are treated as consumers under the ACL when entering into certain types of contract, meaning terms will be prohibited and there will be legal remedies available to those terms that appear unfair. It's a targeted and important change, one that brings fairness and legal certainty to a space that has long operated without these protections. So what has changed? Unfair terms in certain standard contracts involving owners corporation and community associations in New South Wales are now prohibited. Specifically, the new rules apply to contracts involving the supply of goods and services in owners corporation, for example, strata management agreement, building management contracts, cleaning, gardening, and so on. The other one is sale or grant of interest in land to an owners corporation or community association. These contracts will now be treated as consumer contracts under the ACL, meaning they are subject to the same unfair contract term rules. It's important to note the new rules don't apply to existing contracts that are already in force on 1st of July. But if a contract is renewed or varied on or after that date, the reform does apply either to whole of the contract if renewed or to updated terms if varied. And once they apply, they only apply to conduct after the renewal or the variation, not retrospectively. These changes have been implemented by Section 32A of the Fair Trading Act in New South Wales through Schedule 3 of the Strata Scheme Legislation Amendment Act 2025, effectively extending the ACL unfair contract protections to strata-related contracts in New South Wales. So what is the test? So for the purposes of today, I'll call this the Section 24 test. So under Section 24 of the ACL, a contract term is considered unfair if it meets the following limbs. Firstly, it needs to cause significant imbalance between the parties' rights and obligation under the contract. Second, it's not reasonably necessary for it to project the legitimate interests of the party that it benefits. And 3, it needs to cause detriment, financial or otherwise, if applied or relied upon. It's worth noting the term doesn't need to cause actual harm, even the potential for detriment is enough. So when a court or a tribunal is assessing whether a term is unfair, it must also consider how transparent the term is. Is it clear, plain, easy to understand? And the contract as a whole to determine whether the term is one-sided in the context. The federal court has set out some key principles for applying the Section 24 test. Firstly, all 3 parts of the test under it, Section 24, must be satisfied. The onus is on the applicant or the person who's contesting the unfair term to prove points 1 and 3, but it is up to the respondent to justify why the term was reasonably necessary. Further, transparency is a relevant fact, but not decisive. A term written up in plain English can still be unfair, or a poorly written term isn't automatically unfair. The contract is a whole and is considered, but is assessed fairness on the specific term. And importantly, if we turn to Section 25 of the ACL, there is an exhaustive list of what is classified an unfair term. So let's bring this into the real world. Under Section 25 of the ACL, there are examples of contract terms that may be unfair. A number of them are very common in contracts that you will see in your everyday strata obligations. For example, one-sided performance obligation. A strata manager can walk away from a contract at any time without penalty. Meanwhile, the owner's corporation has to give 3 months notice and pay a termination fee. Another one is unequal penalties for termination. A contract imposes a $10,000 early termination fee on an owner's corporation, even if the service has been poor, but a contractor faces no consequence for non-performance or delay. No accountability for subcontractors. A building manager says they're not responsible for the actions of their contractors they engage, even though they choose to instruct them. Assignment without consent. A strata manager can transfer the contract to another company without even informing the owner's corporation, let alone getting consent. And these are exactly the type of contract clauses that will be treated as unfair under the new rules. So what happens if a term is unfair? If a term is declared unfair by a court or tribunal, it is void from the beginning. It has no effect. the rest of the contract can still operate if it makes sense without the term. But there's also serious consequences if a party proposes or relies on an unfair term, including the affected party can take it to court and ask them to void the entire contract or vary some of the unfair clauses. A company may also face additional remedies under the ACL, such as injunctions, damages, and compensation order. And there's also significant financial penalties for companies. I'll take it over to Carolyn. Do you want to give a WA perspective?
Yes, thanks, Julia. I suppose before I talk specifically about WA, I think what's interesting about the unfair contract terms generally is that it's so important that all three of the limbs of the test are satisfied. So we're not talking about what we might morally consider as an individual to be fair or not fair. So the use of the word unfair is a little bit unfortunate because it's suggesting there's some level of moral judgment about it, or that it's the word as we would ordinarily use it in ordinary language day to day. But so it's really important that when we're thinking about whether a term is unfair, that those three limbs of the test are met. And just to repeat them, because I think they're important, the first issue is there a significant imbalance in rights. All of this really is about making sure that one entity that might be said to be the power in the relationship and hold all the cards can't manipulate that situation. So the first issue is there an imbalance in the rights of the parties? One party has more rights than another, or more significant consequences to their favour than another. Secondly, and this is always quite an interesting one in my mind, is the term reasonably necessary to protect that party's legitimate interests? And in other contexts, when we talk about these sorts of interests, what the court has said is, well, look, we're in business here, and it is legitimate in some instances for a company or an entity to protect its commercial interests. That is a valid thing to do. So there's always a bit of a balancing act of, well, is this a legitimate thing to do in a commercial context, and is it reasonably necessary? So I think that's always quite an interesting one when looking at the test. And then the third, obviously, has it got the potential to cause detriment of some kind? So we've got to kind of get out of our heads the sort of general principle of fairness, I think, and really focus on those are the three things that are important when we're looking at it from a legal perspective. So turning to WA, we don't have the clear situation that they now have in New South Wales, that the unfair contract terms of the ACL will apply necessarily. It's in each case, it'll be an assessment of whether their small business provisions apply to the situation, which sometimes they might with maybe a caretaker's agreement, sometimes it might with a strata management scheme, who knows. It'll be an assessment that has to be made with each situation. I'm not aware of any plans in WA to do a similar amendment as has been done in New South Wales. But I think as general good practice, because these provisions are in play, there is an awareness of the importance of fairness in the general sense. I think it's just good business for everyone to be mindful of the need to balance parties' rights more appropriately. And in the end of the day, a lot of these contracts have longevity. So if and when amendments come in, it's better to be forearmed. And also, at the end of the day, these ACL provisions, it's consumer protection legislation. So it is about balancing out power. And I think all owners, strata companies. Sorry, that's the WA term, the strata company. You have perhaps more power than you think, and we would suggest you think carefully about these things and get advice when you're negotiating contracts that could have significant terms going into the future.
Should we be expecting these protections too in other states? I saw a few questions in relation to that as well in the chat. The New South Wales reform could act as a catalyst for national change. Even where the law hasn't changed yet, the risk of enforcement, reputational damage, or legal challenges is growing, especially if the clauses wouldn't survive scrutiny in New South Wales. So while New South Wales is leading the charge on this particular reform, it raises a really important question. What is happening in other parts of the country? To give a sense of the picture, there has been other jurisdictions that have come close. We'll talk about that a little bit later on. Now, while we've been focusing on unfair contract terms in service agreement, there's another key area of reform that is just as important, but often flies under the radar. Let me ask you, how many of you know exactly how much commission your strata insurer is paying your advisors or your broker? And if the answer is not sure, you're not alone. That is why we're now seeing tighter requirements around informed consent for insurance commission. This is about transparency, disclosure, and legal compliance when financial advisors are receiving payment tied to general insurance policies, including strata insurance. Now, before we dive into the detail, let's be really clear on one important point. The informed consent requirements come from the Corporation Act and the ASIC Act, which are both Commonwealth law. This means they apply across all states and territories. So regardless of which jurisdiction your strata operates in, if an advisor or broker is earning a commission from the sale or renewal of a general insurance and providing personal advice to retail clients, they now must obtain informed consent under these national laws. So let's break it down. Under Division 4, Part 7.7a of the Corporations Act, any Australian financial service licensee or authorised representative who receives a monetary benefit, like a commission, from the sale or renewal of general insurance must obtain consent from the client. This applies when personal advice is being provided to a retail client, and yes, that includes strata insurance and residential building insurance. So why does this matter? Because without informed consent, those commissions may be treated as conflicted remuneration, which is prohibited under the Corporations Act. So to comply with the law, an advisor must disclose some very specific information going forward and get consent in writing. This includes the name of the insurer, the rate of the commission, how often it's paid, and how long, frequency and duration, the nature of the service provided in return, a statement that consent is required by law, a statement that consent is irrevocable. Now, does consent need to be obtained every year, given that policy years are generally year by year? Not necessarily. If the original consent clearly states that it applies to renewals but hasn't changed, the consent can carry over. But if there has been a change on the rate or the frequency of the commission, the advisor must disclose the new terms and obtain fresh consent. If the client doesn't consent to the change, the original consent continues to apply, but only to the original terms. There's also record-keeping obligations now imposed. There's no prescribed form of consent, but it must be in writing. The licensee or authorised representative must keep a written record of the client consent or any variations, provide a copy of the consent to the client, and retain it for 5 years. This is set out in section 1101C of the Corporation Act.
This is one of my areas of particular interest is disclosure, because it happens in lots of different areas of the law, in franchising, in most regulated industries. It's one of government's favourite ways of regulating industry and trying to achieve fairness is to require disclosure. And whilst I think it is a very important thing, particularly in this context where you're disclosing payments and receipts of money that arise from an arrangement. I think it only goes so far, the sorts of requirements to provide disclosure. Obviously, there are limitations, as you've identified, about how often it's given. I think also one of the problems with disclosure generally is it's relying on people understanding what it means and reading it. It's got to be provided in a way that they actually understand and realise the consequences of it. And often disclosure can be a bit lost because it becomes such a big obligation. There's too much information for people to absorb and understand. So I think it's a very positive thing and it's a needed requirement. Obviously, as we know, there's been a lot of issues around this. It's been responded to. But I think at the end of the day, and I've just seen some of the questions there, I think it really is a matter of disclosure is one part of the equation. And I think really it's about educating owners to really understand when they're given that disclosure what it means to ask questions, not to just take it as written. Because the purpose of disclosure is to give them enough information to make an informed decision as to whether they're willing to proceed with the arrangement. That's always my issue with disclosure, is how effective is it? It's important, it should be happening, but how can we make sure people truly understand what it means? And obviously we're biased and we'd say get advice about it, but that's obviously not practicable in every situation. But disclosure is definitely an interesting one, but I think this is really positive. We have in WA, and I'm sure there's in other states it's the same. We have disclosure obligations, more from strata managers to their clients. That is to say, what are they getting from the arrangements, and those are continuous sort of, if a contract's entered into and the arrangements change, the disclosure, there are continuing disclosure requirements. But this obviously is really putting a burden also on the insurers and the financial service providers to step up and provide more information in a particular format. So that should also make, in my view, in WA and other states, the strata managers' disclosure obligations, I think it's going to make it easier for them to meet those obligations because they have the source information, hopefully in a better form. And I think it should be a three-way conversation. It's going to be interesting to see how that impacts. All of this is about the consumer, that is the owner's corporation, strata company, and the lot owners. Hopefully it is going to bridge the gap, the information gap, a little bit going forward.
It's my understanding that there is confusion about who needs to obtain this consent in writing and whether the strata managers are required now to obtain that consent in writing every year at renewal time if there's a change to the conditions of the renewal.
Yes, so I would say that it would be best practice that they do obtain informed consent. Obviously, strata managers do obtain a commission in terms of either they're dealing with the brokers directly or they are dealing with insurers directly, and they do get a paid commission. So they should be getting informed consent.
Okay, thank you. Thanks for that clarification.
So I do agree that there should be more transparency moving forward in terms of insurance commissions and obligations. In Victoria at the moment, we're seeing a number of insurers pulling up due to occurrences of fire damage, and we've got premiums going up by at least tenfold. Moving forward, there should be more transparency between all parties involved in understanding where the increases are coming from and who's benefiting from them. I just wanted to next touch on what everyone should be doing moving forward. So firstly, I think everyone should be auditing all existing contracts thoroughly, review every service agreement, strata management, building, cleaning, gardening, flag any clauses that may be one-sided, unclear, or potentially unfair under the ACL. While many of you might have contracts that don't get captured by the new reform just yet, it's still good to go through them at an early stage. And then when you have renewal, you can at least raise those matters early on. Remove or amend any risky clauses. Don't wait for renewal. If a clause wouldn't stand up under the new rules, change it now if you can. Prioritise clauses that limit liability, impose penalties on one party but not the other. Formalise informed consent procedures for commissions. So if your organisation receives or facilitates insurance commissions, ensure that you're collecting valid, written, informed consent. Follow ASIC requirements, disclose the insurer, commission rate, duration, and record the consent and keep that on file. Train strata managers and committees. Many compliance issues start with a lack of awareness. Deliver targeted training to committee members and staff on their legal duties, the ACL reform, and how to identify unfair terms. And then involve legal expertise early. I recommend before you renew, vary, or enter into a contract post 1st of July, seek legal advice if you can. The cost of non-compliance, void terms and penalties can cause reputational damage and far outweigh the cost of doing it right in the first place.
They're really good points, Julia, and I think more generally, like you've identified, now is the time, it's a good time for everyone to regroup, for strata managers to have a look at they're presuming they're using standard form contracts of some type. Obviously, SCA provide, if you're members, you've got access to certain precedents, and I know in WA that those precedents have been looked at in terms of compliance with unfair contract requirements. Strata managers, your precedent might be old. It might not only need to be looked at from the point of view of unfair contracts, but wearing my other work health and safety hat, it will need to be adjusted to take account of the work health and safety changes that are, whilst it's separate legislation, it's mirrored across Australia, essentially most of Australia. And I think it's just good business. It'll put you ahead of the game. Owners are becoming more and more aware of these issues. If you can go out to the market to say, look, we're aware of these things, we have had our contracts looked at, we've thought about this, and it's been factored into our precedent contract that we're presenting to you. I think there's something to be said for that in the market. For strata companies, body corporates, etc., and owners, I'd say don't just take what you're given, so to speak. You do have some bargaining power, and you do have actually the legal obligation to the owners group as a whole, if you, as a council or a committee, to make sure that what's being entered into is in everyone's interests. So that includes looking at this question of unfair contract terms as well as other things. Every strata manager will be different, but talk to them, see if there's room for movement if you think something is inappropriate in your situation. Remember, these Section 24 unfair contract terms is about each particular situation, so things will vary, and it may be that a clause in a contract in one scenario is fine, but in another it does operate unfairly. So I have the discussion with the strata manager, and I'm talking about strata managers, but obviously there's caretakers agreements and things like that will also be relevant to unfair contract provisions, but the same applies, and now's a good time. And there's nothing stopping you if you're in the middle of a term from varying your contract if both parties agree. Now's the time to start regrouping, all parties just sort of being mindful of this. And the disclosure is it's all part of the same puzzle, really. That's why I think New South Wales, it's all been rolled into one, because it's all about consumer protection. It's all about making sure that the party that might be seen to be the weaker from the point of view of bargaining position is protected as best as is, again, reasonable. It's not about making sure they get the best deal they could possibly get. It's about balancing interests, not making sure that one party is not able to cause detriment to another or get a significant benefit.
Thank you so much for that. It was a really great discussion. I really appreciated it. I think we had lots of comments come through, so people were obviously interested in the information that you were sharing. There were just a few questions about clarification, if we could just address those quickly at the beginning. So one of them was when you're talking about the consent in writing regarding renewals of things like insurance contracts, was that consent from the committee or from every single owner, or how was the consent provided by the owners corporation, body corporate, strata company?
Look, that would be from the committee. And then you'd have at least that record. You wouldn't have to get it from every single lot owner.
Is setting limits on liability an unfair contract term unless the limits are the same for both sides?
Yes. So from my perspective, if the limits are the same for both sides, then that would obviously be a fair contract term. If it was to impose a liability on one side but not the other for the same or similar conduct, that would be unfair. You'd obviously have to review the whole contract to see what are the obligations on one party as opposed to another party, because it could impact one, but then have no effect on the other based on any obligations or warranties they've made under the contract.
And we also just had another comment on informed consent that was, it's important to note that strata managers in the financial services context are generally not authorised by the AFS licensee principles to provide personal advice, and that the informed consent requirements only apply where personal advice is being provided or is likely to be provided.
Yes, that's correct. But if you're giving advice on which insurance you're going for, you're actually giving advice. So you can be classified as a representative of the financial advisor.
New South Wales, in my strata plan, the building manager has the authority to retain contractors on behalf of owners. The strata committee and the strata manager both seem pleased to assign this responsibility to the building manager. I'm concerned that this arrangement may create a climate conducive of corruption or secret commissions between the building manager and the contractors. What protections are there to guard against this, and does the legislation address these concerns?
Look, the owners corporation retains the power to define and limit the scope of a building manager's authority under Section 67 of the Strata Scheme Management Act, including imposing conditions around procurement, approval, or financial interest. The Strata Scheme Legislation Amendment Act will introduce a new Section 70A into the Strata Scheme Management Act, which states that a building manager must not fail to act in the best interest of the OC or breach a duty prescribed by the regulations. A violation of this may give rise to penalties of up to 100 units for an individual or 200 units for an entity. While the section has not yet commenced, nor has there been any corresponding regulation provisions disclosed yet, the possibility of the amendment enhances duties on building managers, which will include disclosure commissions when they introduce contractors to the owners corporation. Since Section 70A hasn't been commenced yet, the owner may want to review the building management agreement and consider placing limitations on the building manager's ability to exercise their duties.
New South Wales, given the power and knowledge imbalance between strata owners and the professionals they contract with, do legal principles need to be modified in any way to achieve a fair outcome for strata owners?
The power and the knowledge imbalance between individual strata owners and the professionals they contract with, such as strata managers, building managers, and contractors, is a real ongoing concern in the strata governance area. Some owners may lack legal or technical expertise, making it difficult to scrutinise contract challenge decisions and identify conflicts of interest. Parliament has begun to address this issue, notably the proposed amendments to Section 37 of the Strata Scheme Management Act will introduce mandatory training requirements for strata committee members. I think this is a positive step as it aims to improve decision-making within the owners corporation by ensuring that committee members better understand their duties and the legal framework which they operate into. Educating committees are more likely to ask questions, seek quotes, monitor performance, and resist overarching conduct. Notably in New South Wales, NCAT plays a key role in resolving strata disputes. It's designed to be an accessible, low-cost forum where individuals can represent themselves. NCAT also offers procedural guidance to unrepresented parties, which helps reduce the disadvantage that owners may face when dealing with professionals who are legally advised. That said, there may be still scope for further involvement. For example, know that I mentioned before the introduction of mandatory duty of disclosure for building managers and strata managers regarding commissions or referral fees. And there's that reform coming out. Expanding unfair contract protections to cover standard form strata-related service agreements more explicitly. And then also giving owner corporations the statutory right to periodically review or terminate long-term service contracts without penalty. And then also requiring greater transparency in tendering and procurement process. So while Parliament is making progress in addressing the power imbalance through training and future regulating reform, there's still a need for further work to occur in the strata space.
New South Wales, our strata management contract doesn't expire until 2027. Should we review the contract sooner? And if so, will that have any impact on our current contract?
It is advisable that you review your strata management contract before it expires, even if the term runs to 2027. While an early review won't automatically change the legal effect of the current contract, it will help the OC assess whether terms are still appropriate, ensuring the manager agent is meeting expectation and is well prepared in advance for renewal, renegotiation, or replacement of the contract. Under Section 51B of the Strata Scheme Management Act, Strata Management Agency agreement cannot exceed 3 years unless it's entered into at the first AMG of the Strata Scheme, in which case the maximum term would be 12 months. Once the term expires, the owner's corporation may choose to reappoint the strata manager by resolution at a general meeting. While you're bound by the existing contract until its expiry, in this case 2027, the standard SCA agency agreement usually includes a clause allowing for annual reviews of services and charges. This review clause gives parties the opportunity to assess the performance and satisfaction, adjust service levels and fee structures by mutual agreement, of course, and raise concerns about compliance, transparency, or communication. So in short, while reviewing the contract won't change the legal obligations unless both parties agree to a variation, it's still a strategic and prudent step to take in the interest of the owner's corporation and also lot owners.
Julia's right about in the previous question too about we've come so far, but there's more to go. Like I said before, disclosure is part of a bigger picture. I noticed some of the comments coming through as Julia was talking about that issue of the committee, the council bear a responsibility to act in the interests of all owners. And I think particularly now things are becoming more complex with strata management, these new provisions coming in, different jurisdictions having different arrangements currently, things like work health and safety and all sorts of other legal developments. Again, whilst it sounds like we're advisors telling people to get advice for our own benefit, it truly is, in my view, so important. And also, I think it's consistent with the committees and the council's obligations to act in the interests of all owners to get advice about these arrangements. They're long-term, they're significant for the body's corporate strata companies and lot owners. So I think we need to be mindful of how important it is to get advice. And as Julia said, you don't want to get it in a panic at the end when you need a new strata management contract or caretaking agreement in place. Start planning for the future and doing those sorts of things sooner rather than later.
Since 2015, Section 79D of the Fair Trading Act has defined an owner's corporation as a consumer, suggesting that the entire Australian consumer law applies to it. However, the recent addition of FTA Section 32A now explicitly subjects owners' corporation contracts to ACL Parts 2 and 3 and 5 to 2. This raises the question of what practical differences, if any, Section 32A makes.
So while Section 79D recognises owners' corporation as a consumer, the legal protections it provided were incomplete and uncertain, particularly in relation to unfair contract terms. So Section 32A resolves this gap by explicitly applying key ACL protections to OC contracts, ensuring that strata schemes have clear rights to challenge unfair terms and standard services under the consumer law. this is a significant reform that strengthens fairness and accountability for strata contracting.
New South Wales, are the new contract rules for strata managers only applicable to new terms? What if there are still 12 months to expiry of the original contract term? This is most relevant for insurance commissions if we wish to change to dealing directly with an insurance broker.
The new contract rules introduced only apply to new or renewed agency agreements made after the reform commenced, so 1st of July. Existing contracts, similar to this one, where there's 12 months remaining, continue under the original terms until they expire, unless both parties agree to amend or terminate early.
Victoria, as a non-committee owner, what can I do if the committee and owners corporation are not doing the right thing? For instance, engaging contractors with whom they've had prior relationships rather than obtaining 3 quotes. And more concerning, not ensuring the proper certification after work has been completed. The contractors are charging well above the industry price and in advance before work has started.
As a non-committee member, you have various avenues available to you if you suspect that a committee or the OC is failing to act properly, and particularly in relation to financial management, procurement practices, and potentially conflicts of interest. I mean, we'd have to understand the prior relationship, whether this is someone that they've previously used or whether this is a friend, but just more generally, the available avenues including accessing records pursuant to Section 149 of the Owners Corporation Act. You'll be entitled to access records, including contractor invoices and procurement documents. Alternatively, you can write to the OC manager and raise your concern or follow the internal dispute resolution process. Another avenue is that you can convene a special general meeting under Section 74. If you have support from 25% of lot entitlement for the OC, you may seek to dissolve the committee and vote a new committee, such as yourself in. You can also submit a motion to be included in the next general meeting, requiring the OC to adopt a procurement policy. And then if the OC fails to address your concern and you believe that they have acted against their statutory duties in the OC Act, you may lodge an application with VCAT under Section 162 of the Act. I should also add that members of a committee or a subcommittee are not personally liable for anything done or omitted if it's done in good faith as well.
I think certainly in WA, and it may be the same in other states, and the tribunal might hate me for saying this, but our tribunals are underutilised in a lot of ways, because certainly in WA, it can often be a more cost-effective way of resolving an issue than war by correspondence and so on. Certainly in WA, you lodge your application. Doesn't have to be an expensive exercise. Even if you're using a law firm, we can, get the application lodged. And in WA, often it'll go straight to a mediation before a member of the tribunal. Even on the first directions hearing, they'll say, okay, can you go to mediation now? They have another member who's they call them the member who's registered for the day to do the mediation. So, and more often than not, things can get resolved at mediation. So I just encourage people to look at that option more openly, because also I find you get in a war of correspondence and then people get more and more entrenched in their position. And they're they're heads butting, and then it becomes more and more entrenched and harder to see the wood for the trees and resolve the issue. Whereas if you go to a tribunal, you've got the member there, you can get into separate rooms, and it's a far more efficient and effective way of resolving a dispute, which is, as we all know, in everyone's best interest. So I just thought I'd raise that because Julia mentioned tribunals. I think we need to utilise that service a bit more effectively across Australia.
At this point in the session, we always like to go back to our presenters and just ask them if they have any final thoughts that they'd like to leave us with, just to wrap the session up. And Julia, I might go to you first.
Look, from my perspective, it's all about transparency and accountability. I think the reform that's coming in is a great reminder that this is a consumer jurisdiction, essentially. While it's not recognised previously, it is showing the shift that we're going into that direction. And so it is a timely reminder to actually review all your contracts and be prepared.
Wonderful. Thank you. And Caroline?
I couldn't agree more. it's a time for change in strata and good change. And I think we all as a community can use that to the benefit of everyone in the long term. While sometimes it's seen that these sorts of changes might be detrimental to strata managers, caretakers and others, I think if we look at it the right way, it can be seen as a very positive thing across the board for everyone concerned, and improve relationships and so on. So I think this is the beginning of what are going to be some interesting times ahead in strata. Watch this space, as they say.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.